Yo, are you recording? Oh my god!
They see me rolling, they hating, patrolling and trying to catch me
I'm telling you, I didn't do it.
Sure you didn't.
I demand a lawyer then.
Nah.
You can't just sentence me.
Actually, I can. How about we do 3 years in prison?
What? I'm going to take this to the Supreme Court, Cochran.
Lol? How about we make that 5 then?
This isn't the last of me, Cochran.
Well, actually, it is the last of me because I'm retiring, so good luck with that, fool. Court dismissed.
When you try your best but you don't succeed.
Alright. That's not exactly what happened, but it's pretty close. In the early hours of June 3rd, 1961, between the hours of 12 and 8 a.m., a burglary happened in the Bay Harbor pool hall in Panama City, Florida. A door was smashed down, and a record player and cigarette machine were completely destroyed. And to top it all off, all the money in the cash register was stolen. And that's as far as I know. You know what happens next?
Yeah, so at 5:30 a.m. in the morning, some idiot saw Clarence Earl Gideon with some money in his pockets and a wine bottle in his hand. So as a result, he got caught. But at the court, however, Clarence Earl Gideon vouched for a lawyer, but he didn't get one. So his actions itself was considered as a misdemeanor. However, since his actions was committed with a malicious intent, his misdemeanor was considered as a felony.
Well, I don't really blame the court though, especially considering his colorful past of petty crimes.
But the thing is though, he decided to appeal anyway against the Secretary of Florida Department of Corrections, H.E. Cochran.
Oh yeah, and that guy retired, and that's why the name of the case changed from Gideon vs. Cochran to Gideon vs. Wainwright.
That's right, but anyway, his petition for a writ of habeas corpus was struck down by the Florida Supreme Court. However, he decided to file a good old writ of certiorari to take the matters into the U.S. Supreme Court, questioning if he deserved a counsel despite committing a felony.
At court, he argued that according to the Sixth Amendment, he had a right to a counsel despite his offense, and this is what the justices thought.
I, Hugo Black, protector of the realm second only to Jesus Christ himself, proudly declare that all the Chief Justices agree that Gideon has in fact been wronged. My words are of God's, and therefore the law of the sacred land.
I, Tom C. Clark, destroyer of injustice, second only to Lord Shiva himself, pronounce that Sire Gideon is entitled to a lawyer according to the Sixth Amendment, which states that in all criminal prosecutions, the criminal shall have the assistance of counsel for his defense.
I, John Harlan, disciple of Muhammad, the Prophet himself, have determined with the guidance of Allah, this is a gross violation of the 14th Amendment Equal Protection Clause. In other words, the existence of a serious criminal charge itself should be considered as special circumstances, requiring the services of counsel at trial.
I, William Douglas, enlightened by the Buddha himself, on the basis of the Bill of Rights, peacefully agree with both Justices Harlan and Clark.
And that's pretty much what went down. In a unanimous 9-0 decision, the Supreme Court ruled that Gideon indeed should have received counsel. But this is really not surprising there was no dissenting opinion, as this was clearly dictated in the Sixth Amendment.
This overturned a previous Supreme Court case called Betts v. Brady, which determined that except for special circumstances where a defendant has a low IQ or illiterate, there was no need for court-appointed lawyers in trials, especially at the state level.
Huge!
I know, right? This is a really good example of judicial activism given its impact.
That's right. After this case, over 2,000 inmates in Florida alone were released after the help of a lawyer. And that's why you have the right to a counsel today.
As for Gideon, he was finally able to choose a lawyer under government's expense, and his name was called Fred Turner. At his retrial, the court decided that they didn't have enough evidence to put Gideon behind the bars.
And that was the case of Gideon versus Wainwright.
I actually did get recognition.
I bring light.